See if we can get it running there.
Okay.
Good evening and welcome to the Grant County Board of Zoning Appeals meeting for April 6th, 2026. Please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Mr. Glancy, when you're ready, would you give us a roll call for attendance, please?
Michael Duke.
Present.
Andy Ellis. Here. Lois Jones.
Here.
Chad Kirkpatrick.
Here.
Sandra Rowan.
Present.
Andrew Webb is not. Ed Hartman.
Here. Thank you. Meeting minutes, we had March 2nd in the packet. As far as approving the minutes, are there any corrections or additions?
Well, I would just say that I did not have minutes for February 2nd in my packet.
Yes, we're
So
doing
We're only just doing
March
minutes.
right now.
I didn't recognize anything.
Okay. If there are no corrections or additions, I'll call for a motion.
Motion to approve?
Second.
We have a motion to approve March 2nd's meeting minutes. Mr. Glancy, could you give us a roll call?
That was Andy Ellis made the motion.
Yes. Michael Duke, second.
Michael Duke.
Aye.
Andy Ellis.
Yes.
Lois Jones.
Yes.
Chad Kirkpatrick.
Yes.
Sandra Rowan.
Yes.
Passes.
Okay. And February 2nd, will that be at next meeting?
Next meeting.
Okay. Okay, old business update for Jack Heimlich.
I'm trying to conduct the swearing in before you get too far.
I'm sorry, I meant to do that, didn't I? Yes, would you
Go
please?
ahead and do that. Ms. Rowan, I want to administer a quick oath, if you don't mind. Go ahead and stand, please. Raise your right hand. Do you swear affirm under the pains and penalties of perjury that you will, in your capacity as a Board of Zoning Appeal member, uphold the laws of the United States, of the state of Indiana, and the county of Grant?
I do.
Very good. Thank you.
Thank you
Welcome
for the
aboard.
reminder too.
Sure.
Okay, is there, under old business, is there any update, Mr. Glancy?
I'd like to, since we have a lot of new members, and this is a fairly old docket that is still ongoing, I thought I'd pass out a packet of where we've been to bring everyone up to speed. Nothing really to act on today.
Yes, sir.
I'm working with,
Thank you.
Miller, Jason Miller, Mr. Miller, to work on a plan. I think we're very close to a plan. We, last week, we did not have time to meet and go over the plan to be able to present at this meeting, but I feel confident we'll have a plan in place to present at the next May meeting.
Okay,
There's a lot of material here. Kind of the background was Jack Heimlich. I assume everyone knows, runs a stone quarry just outside of Upland, and he had purchased another 25 acres and has a mining facility on it and is also selling topsoil from it. And there is also a large stockpile of material debris that's being disposed there. And there's some issues with that since it's in the floodplain. It also, all of the trucks that were bringing in the material were going up and down a county road access, and that road wasn't really built for it, and there's damage to the road. And then it turns into, it started as a code enforcement, complaints from the neighborhood. Folks were asking, about the damage to the road and the large stockpile of material. There's a lot of pictures there. And we're at this point in which the office investigated what types of permits were available, and that they needed a special exception from this board to be able to have the activities that were going on at the site. And so one thing led to another, and we're at the point of developing a plan on what to do with this site and see if it passes this board for a special exception. Anything to add from the members that were here before?
As part of this plan going forward, can you get a good estimate from Mr. White at the Highway Department of what it would cost to repair that road? He gave an off-the-cuff estimate in the hall when David and I were talking to him. It's been a few months, of $65,000, but that was just really off the top of his head guess. But I'd like him really to nail that down.
Okay.
Okay. Does anyone from the board have any questions?
And Todd, just again, because I wasn't here during a lot of this, so the board is being asked whether they can continue to operate and put that aggregate in that site. Is that what I'm understanding?
Yes, and we're exploring all the types of permitting that is required to have that dump site. There's another issue with it as you look through the packet that it is also in a floodplain. And so that is part of why Mr. Miller is involved to do a hydrology study and survey to see what those effects are and what kind of mitigation types of activities need to happen.
He was waiting for the weather to get a little better to get that work done. Have you heard anything from him?
Yes, we were in contact the last couple of weeks, and we wanted to sit down together and look over what the plans were and what he had prepared. And we just didn't have the time. Our schedules didn't work to be able to sit down together.
Okay, so you probably have that for the next meeting.
I hope so.
All right. Is there anything else?
Todd, has there been any activity in that area since the cease order was applied earlier? Well, actually last year. I've been past it a couple of times and I've not noticed any activity in and out of there, but that's been 4 or 5 weeks ago since the weather was cleared. It isn't still sitting there static until we get these issues figured out.
The day after was documented that the day after a meeting, I don't remember which meeting it was last year, in which we told them to cease. That next day, they took a large amount of concrete waste material, large pieces, and closed off that entrance so that there was no more dump traffic on the road. And in the meantime, some of the nearby residents have photographed some limited amount of dumping on the large pile.
where
Which
it was
means they're
blocked
using
off at?
that.
Not where it
using
was
another
blocked off. They were going through the
Another
entrance of
Yes.
the gravel pit.
There's normal entry on the normal,
On the county road, that's what I'm
County
thinking in
road,
terms
right.
of, but there's a back entrance then?
no, that's a front entrance. His normal entrance for dump trucks coming to and from his gravel pit also has a little road
An
that goes
access road.
back to his other property. And that's what they're using, so that they're not tearing up that road any longer, that side road. Okay.
Okay,
Okay,
thank you, Ed.
no problem. All right. Next on the agenda, were there any other questions from the board members? Okay. Next on the agenda.
Yeah, I do
Yeah,
have
go
one
ahead.
more, just because I sat in those presentations that were made by Mr. Miller, or Randall Miller and Associates and such last year.
Mhm.
My recall is that there was not supposed to be any activity with regards to moving that material either in or out until a plan was developed and agreed to as to how to proceed. Did I misunderstand that, or is there a continuation of what Mr. Delancey referred to as being observed by the
I thought it was
surrounding
supposed
residents?
to stop.
That's what I thought, so.
Do you remember it that way? I remember that I thought it was supposed to stop inbound material.
That's the way I remember it. And I'm glad we have the video to go back to, but that's what I remember.
Thank you.
Thank you.
I've not personally taken a site visit.
Okay. Well, we may want to research that before next meeting, in case there's anything else to update on that. All right then, moving on, new business. Nicholas Smith variance, docket 013-26. Is Mr. Smith here? Would you come to the podium, please? Give us your name and address. There should be a sign-in sheet at the podium. This will be a normal public hearing with the rules that we have in place, up to 15 minutes for you to present your petition. Then any opposition, if there is any, will have up to 25 minutes to present their evidence and reasons. And then you will have up to 10 minutes for a final rebuttal.
Okay.
Okay.
My name's Nicholas Smith, 7696 East 100 South. Just asking for a variance in the permit so I can build a pole barn. It's technically front yard, but it's actually on the other side of my driveway. And it'll kind of split the line, just build a 40 by 80 pole barn. You won't see it from the road. Can't even see my house on the road technically, so. You guys they have this map?
Yes.
You guys look at the aerial view. Does that have a picture of my square drawn on it? It doesn't. Anyways, there's a power line that runs from a pole to a power box, and I either have to be north of it or south of it. I would like to be on the north side of it, so I'm not on the power line, but then also that's a flatter area to build. So that's kind of why I'm trying to build it where it's going to be. It's going to have no power, no water. It's just a building and concrete. So
Okay, now, on your picture, where is the building to be?
okay, yeah, it's not drawn on there. So you want my copy?
Is it, it's a blacked out square.
Yeah, there should be a black.
First picture in the
Right.
packet.
Okay, I saw that. Yes.
Yeah, it'll be 100 feet off the property line. I'm not, I would say that it'll probably be 60 feet past that front line of my house.
Okay. Yeah, I was by there the other day. Can't even see back there.
Yeah,
Sure, that's fine with you, privacy-wise.
I
That's
like
nice.
it.
Yes. Where are your septic tank and laterals?
straight north of the house.
Straight north of it, huh?
Yep. Right in front of the house in the big open spot.
Okay. How close do they get to this new building?
I would say 100 feet or more.
Okay. All right. Board, do you have any questions? Okay.
The power line, is it above ground?
It's buried.
It's a buried
Yeah,
line.
yeah. So I don't want to be anywhere
Right.
over it, near it, because if they ever got to replace it, it's going to be a problem.
So with the placement of the barn where you are proposing,
Yeah, I'm going to be 20 feet on the other
north
side.
of
Yes.
where the buried power line is at.
Yes.
So between the existing outbuilding that is there.
It'll be straight
And the
north.
proposed site,
Yeah.
that power line's going to run between the two buildings.
Yes, correct.
Okay. All right. So you and your neighbor share the line that comes.
The line
off of
comes
the road,
overhead
Overhead to,
the pole, jumps to my property, and a pole goes down and is buried
okay.
to the house.
All right, I saw the transformer on one of the poles back there.
Yeah, I watched that thing
Up
catch
there
on
by
fire.
your neighbor's
You're right.
driveway.
Yeah.
I'm sorry, I didn't mean to cut you
No,
off.
no, you're good.
Okay.
Okay.
Are there any other questions?
I have one.
Yes.
So I was briefly reading through this and it said that there was no, would not be visible from the adjacent property. Is that correct?
Yeah, I don't think anyone will be able to see it. There's a row of trees along this fence row, so my neighbors probably won't be able to see it either.
Okay, because it looked like there was a break in the trees, but maybe that's just the way
Yeah,
the
this looks
photo
like
looks to me.
yeah, this is an older photo. I have a whole driveway built here now, so this goes back probably 8 years if I had to get it.
Thank you.
Okay. All right. Any other questions? If not, you may be seated.
Thanks, guys.
Is there anyone here in opposition to this petition? Hearing none. I'll close the public hearing. And it's time for deliberations by the board. And if you have any questions, that you need Mr. Smith to come back up, we could do that. Okay, hearing no questions, I will entertain a motion for this.
Make a motion that we accept the variance.
Okay, we have a motion to accept the variance.
Second.
We have a second. We had the motion by Mr. Kirkpatrick and the second by Mr. Duke. You can give us a roll call when you're ready, Mr. Glancy.
Michael Duke,
Aye.
Andy Ellis,
Yes.
Lois Jones,
Yes.
Chad Kirkpatrick,
Yes.
Sandra Rowan.
Yes.
Motion passed.
Motion passes.
Thank you. Next on the agenda, Jerry Futrell, variance 16 feet 3 inches for an accessory building in the front yard, docket 014-26. Okay, Mr. Futrell, if you would, sign in, please.
All right.
Well, sir, when you're ready, you can begin. Tell us a little bit about your petition, why you'd like to do this.
Name and address first.
Sure.
Jerry Futrell, 3618 North, 300 East, Marion. I'd also like a variance for an accessory building. The reason for the variance is the building will be 16 feet closer to the road than my house, which is considered the front yard. I'm fortunate enough to have a large yard. The house is 295 feet from the street, and the accessory building will be approximately 280 feet from the street. I talked to my neighbor. I'm sorry I didn't bring a letter from him. I talked to my neighbor that lives directly across the street, and he has no problems with it. He said when he got his variance, he got a variance because he built a garage in front of his house, and he just, I just didn't get a letter from him, I'm sorry. I just really don't know what to say. Grant County Surveyor looked at it and he said there was no issues. Grant County Health Department looked at it. They said there was no issues. And I just would like to build this building in the location it's at. If you have the picture, you can see that, if you can see where the accessory building will be there, there's already a drive going into the front of it. So if I can't get this variance, I'll have to redo the driveway that's already there. I assume there was an existing building there before I bought the property, and it wasn't there once I bought the property. I don't really know what else to tell you. From the front yard to the building's 280 feet. From the back of the building to the backyard's 240 feet. To me, that seems like quite a distance. Yeah, north and south, I have 460 feet to the south side, over 700 feet to the north side. It's not going to be a tall building, so I'm going to be 10-foot sidewalls. I'm also not putting a steel roof on it. I'm going to put a shingled roof on it to match the house, to make it more appealing. One thing I'm embarrassed to say right now is I have a semi-trailer in my yard for storage, and I'm trying to get rid of it. I'm sure the neighbors like it, like at least that I do. So, just trying to clean my property up.
Okay. Board members, do you have any questions?
Yeah, is this going to be used for anything else other than storage?
No.
Okay. I don't believe I have it on the picture here where it'll be. Is it south of the house?
Yes.
But it looks like where there's a little driveway.
On the driveway, you see where the drive turns into the house?
Yeah.
You see where it turns to the right?
Yeah, and then there's a little white square there.
Well, that's probably it. Yeah.
Better drive.
Yeah.
Like another guy that said it.
All right, very good. And where are your septic tank and laterals?
The septic is directly in the front yard of the house. That's approximately. The septic's over 150 feet in front of the house.
All right. Do you have any additional questions?
I just asked, any prospects of electrification to the building, or are you just going to, or are you not going to have electricity to?
No, it'll have electricity. I have a tractor. I have some grandkids' toys out there. It'll eventually, I'd like to finish the inside, but I don't know if that'll happen in my lifetime or not. But when I walk out there, there will be lights. When I built my home, I&M or whoever the electric company is out there, they brought one of those boxes and put it in my front yard so I can go to the house and then go. If you see where the driveway splits, that's where that electrical box is, and I would get power from there to the building.
Okay, anything else? All right. Go ahead.
The electrical is all underground. They brought it from the street to the house underground.
All right.
Thank you.
You may sit down.
All
Thank
right.
you. Thank you. Is there anyone in opposition to this petition? Please come forward. Seeing none, I'll close the public hearing and we'll open this up to any board deliberation.
I make a motion that we approve the variance.
I'll second.
Okay, we have a motion from Mr. Ellis and a second from Mrs. Jones. Todd, when you're ready, would you give us a roll call vote?
Michael Duke,
Yes.
Andy Ellis,
Yes.
Lois Jones,
Yes.
Chad Kirkpatrick,
Yes.
Sandra Rowan.
Yes.
Motion passed. Thank you. You have your variance, sir. Okay. Next on the agenda is White Rock Holdings LLC, appeal of administrative decision, docket 015-26.
Yeah. Some more?
Mr. President, if I may, while Mr. Glancy is passing that out, just remind everyone about the findings of facts and how important those are to fill out.
Yes.
Thank you.
Have you been getting them passed out to you? Okay. If you can, fill them out. Okay, board. What we have now is an appeal of the ruling by the office, and we will handle this like we do a normal public hearing. The person with the appeal, White Rock Holdings, will be first, and they will have up to 15 minutes to present their case. At which time, Mr. Glancy will have 25 minutes to present his side of the issue. At the conclusion of his 25 minutes, Then we will hear again from the petitioner, so to speak, White Rock Holdings. And they'll have up to 10 minutes to rebut the administrative decision. Okay, if you would, sir, state your name.
Point of order?
Yes,
If I may.
okay.
We've been presented here right now at the time of the hearing with a substantial amount of information just perusing through it.
You're not responsible for that information because it was just presented and not given in the packet a week before. So, and what we're deciding is whether or not we will uphold the administrative decision,
Understand?
if we will, or if we would modify it, or if we would reverse it. We're not going to decide on if the tower will be built in this hearing. That if we reverse the decision or modify it, that would come later at another meeting of this board. Okay?
Okay.
So we are not deciding
Not to
whether or not the tower
piggyback on
can be
that, but
built.
what is the requirement for the petitioner to submit information prior to the meeting?
Well, it needs to really go out in the packet for us to have time to review it. And there are dates of when it must be submitted to the office to make the packet. So
That's my understanding.
materials submitted, I believe, 3 days in advance can be given to us at the meeting. But again, you can't be expected to know all that material.
Fair enough. So we are making our
Decision
the
is
proceeding here is
simply on
based
the,
upon the information that was provided in the packet
Yes,
to us.
what
That's
was
the
given
evidence
to
that we
us
have and what will be
ahead of
verbally
time.
communicated.
right, and what we hear in this hearing.
Thank you, sir.
Yes.
So what exactly are we voting on tonight?
We are voting on the administrative decision that was made by the area plan office. If it is, well, and we're going to hear the evidence on it as well as what was in your packet, but in the short of it, they petitioned for a cell tower in Matthews on the said lot, and Mr. Glancy rejected the petition at that time and did not allow it to be brought to the board. They are appealing that decision to us. And so if we find in their favor, then they would come to the board in a future meeting for the actual petition to build a tower. And if we uphold his decision, then
Come back to BZA.
their only recourse would be judicial review with the circuit or superior court.
Do you agree? If they deem the application complete, we don't have BZA for that. That'd be an administrative application. Yeah, it depends on how it.
Okay, sir, would you state your name and sign in then?
Yes, happy to. And I just completed the sign-in. My name is Kyle Russell-Terrence. I'm an attorney with the law firm of Dentons in Indianapolis, 10 West Market Street in Indianapolis. I represent a telecommunications facility developer called White Rock Holdings. As has been offered in introductory comments, we submitted a permit application to Mr. Glancy and his office with respect to construction of that tower. Thank you in advance for your time and consideration of this matter. We're here on an appeal of that administrative denial of the wireless facility permit application for the proposed telecommunications tower site. As a point of order, the binder that I presented to you this evening is duplicative of all the documents you've received so far. It is merely presented so that I can reference tab 1, tab 2, tab 3, tab 4, et cetera, as we navigate between exhibits and other documents, but it is the exact same materials. The only material that would be different would be on tab 1, which is simply a map of the surrounding area. Certainly in the board's discretion about whether or not to view the materials previously submitted or the materials included in the binder this evening. On tab 2, you'll see that a proposed site plan with the construction drawings. Tab 3 is Executive Director Todd Glancy's memorandum dated September 25th, 2025, issued in connection with the denial of the initial application. Tab 4 is a memorandum in response to that from my office. And tab number 5 is the subsequent March 9th correspondence from Director Glancy denying the revised site plans, which generally denies the application without any further basis or specification beyond the September 2025 issuance of denial. At a very high level, the application complies with the Grant County area-wide zoning ordinance. The application complies with applicable Indiana state law and federal law, and the denial is based on grounds that are legally preempted by state or federal law, or issues that have been addressed or remedied by the revised site plans and the engineering evidence submitted by White Rock Holdings, and a subsequent denial that provides no additional substantive basis. So ultimately, the request before you this evening is to reverse the administrative decision and approve the application as submitted. As noted before my presentation, the petition will not be a matter that the BZA determines. Instead, and this is a point of clarification, this permit, this application, is a matter that goes before Director Glancy. He reviews the application and effectively approves it or denies it. What is bringing us before you tonight is that he has deemed it incomplete, or his office has deemed it incomplete. So I'm standing before you this evening asking on behalf of my client to deem the application complete, so that then the Director Glancy's office can review that application and ultimately approve or deny it. The cell tower and its permitted use within the zoning district would not come before the BZA for an ultimate approval. I just wanted to clarify that.
I don't know that we agree with you on that, but proceed.
Understood. The county's position, as reflected in tabs 3 and 5, have concern regarding fall zone and setback requirements. I point you to tab number 6, which is Indiana Code 8-1 32.3-17, and I'll summarize it very, very simply that the local fall zone requirements are preempted by state law. So a professional engineer, as we've submitted to you in tab number 7, has certified that the collapse zone, the fall zone of the tower, if the tower were ever to fall, would fall within the contained fence site of the tower. As I said, that PE, that professional engineer's certified engineering analysis was submitted with the application and again this evening. And the legal effect of that is that the burden shifts to the county. So to rebut that with its own evidence, despite the determination from Director Glancy's office, the county has not engaged its own professional engineer to rebut that evidence. So the application, as I will argue tonight, is complete based off of, as provided by state statute, that we have submitted our engineering analysis. If ultimately the county elects to provide its own analysis that rebuts it, then state statute creates a mechanism for us to resolve any conflict between those engineering studies. The conclusion here is that the fall zone objection is preempted and that cannot support a denial of the application. The next grounds is the zoning and residential adjacency. So the county's concern is that the zoning classification and proximity to the residential R1 property. The undisputed facts of the matter are that the tower and the tower compound, meaning the fenced-in area, are located entirely within the general business zone portions of the property. Admittedly, this parcel, as shown on tab 1, is a split zone parcel, partially general business and partially residential. But the entire tower and compound fence site sits within the zoned general business designation, and towers are permitted by right in general business under the county zoning ordinance. There has been an additional step taken by White Rock following the initial application. Even though the residential adjacency is not prohibited, we have revised our plans because at initial application, the first time we submitted the application last year, the access to the site and the utility improvements were within and crossed over that residentially zoned portion of the site. In response to that, when we issued our letter in response to Mr. Glancy's September 25th letter, we revised the plan so the access, the utilities, the fence site, and all of the tower and the compound all sit within the general business zoning designation, and all originate or terminate exclusively from East 10th Street, again, within or across that general business zone portions of the property. There are no improvements related to the residentially zoned parcel contemplated by White Rock in its plans. Again, the ordinance is satisfied and the county's concern has been addressed with respect to any improvements within the residentially zoned area. Other topics of concern raised or at least addressed in Mr. Glancy's memo have been co-location, meaning location of multiple carriers on the tower, and the need for this sort of tower. The evidence in the record in tab 8 would be a sworn affidavit from Verizon's radio frequency engineer, and the affidavit confirms that there's a significant coverage gap. That significant coverage gap exists and can only be remedied by a telecommunications facility site located within a certain jurisdiction, a certain coverage radius of which this proposed site sits within. There are no other viable co-location alternatives. There are no towers within 1 to 2 miles of the existing site, and certainly no towers within the search radius that would allow for co-location. And that evidence has been unrebutted by Mr. Glancy's office. The evidence submitted in our materials would address White Rock's intention to co-locate, meaning have other users, telecom users other than Verizon on the tower in the event that they have interest and an arm's length transaction contract can be worked out. As I've mentioned, governing law, the Telecommunications Act of 1996 here, the legal standard is the local authority, meaning the Grant County Planning Department, may not deny an application if it prohibits or effectively prohibits wireless service. So the application here has a documented coverage gap in the town of Matthews. There are no alternatives, and ultimately a denial of this application would be an effective denial prohibiting service within this coverage gap area because there are no alternative sites. So we both have the state law requirement with respect to the fall zone, and we have the federal law with respect to service and location of a tower within this small coverage area of the town of Matthews. Any denial of a telecom permit must be supported by substantial evidence. Based off of our evidence and the lack of evidence from the planning department, that standard has not been met. In conclusion, the summary of my key points: we have a fall zone objection that was preempted by state law. We have a zoning objection, which we've been fully compliant with and we're permitted by right as we're located in the general business zoning district. We've revised our plans to eliminate prior concerns of improvements within the R1 residential district. The record, both written and oral this evening, establishes a clear service gap, no alternative towers or other location opportunities. The federal law weighs strongly against denial, and the subsequent denial of March 9th provides no additional substantive basis. For the record, I'd like to incorporate by this reference all the written materials previously submitted to Mr. Glancy's office, as well as those submitted previously to this board. I would request a reversal of the administrative determination and approve the application as supplemented. White Rock, as communicated to Mr. Glancy, is committed to being a good partner with Grant County and the town of Matthews. The project is necessary to provide reliable wireless service to the community. I would ask anyone in the audience, to the extent that they are here, that support the construction of the wireless facility as presented, to either raise their hand or stand in the audience. From my position in the room, I'm seeing about 6 hands of the audience raised. I'll reserve any follow-up comments for my rebuttal opportunity. Thank you for your time this evening. Happy to answer any questions.
I don't know whether or not, are you familiar with what the engineering fall zone suggests? What is the actual fall zone?
The fall zone would result in a collapse.
I know what that is, the distance.
Entirely within the compound site, so entirely within the fenced area.
How tall is the tower?
199 feet, including the lightning rod at the top.
So the fences are going to be more than 190 feet all the way around the tower.
Ultimately, the engineering of the tower collapse on itself. So instead of a tower collapsing from the base ultimately and falling, it will fall within the compound by falling within itself, collapsing within itself. So it would not fall at 195 feet or beyond that.
And then based on what kind of forces that were applied through the engineering study?
With respect to that, I would draw your attention to the tab number 7 with Sabre Industries issuing their signed affidavit of compliance that speaks to basic wind, speed, pressures, and ultimately the structural stability of the site being impacted by that.
So it'll fall straight down. That's what you're suggesting, it'll fall straight down.
I'm suggesting what's in the letter, sir.
Thank you.
I'd like to follow up on Mr. Ellis's questions about the engineering articulation here by, Mr. Jack R.E. Ma Jr., if I mispronounce his name, I apologize.
Yes, sir.
How many structural elements are there in the tower from the ground to the top at 195?
Yeah, respectfully, that question goes to the integrity of the structural stability of the site and the issuance of the letter, which is outside of the appeal that's being sought tonight.
Well, I might take a couple more questions here because I don't know if I agree with that interpretation. My reason for asking how many structural elements, and then how many sections are in each structure, or how many structural elements are in each section of the tower, and at what point, as it's articulated in his memo, assuming that the wind, and this is in the final paragraph, assuming the wind pressure profile is similar to that used for the tower is most likely to buckle at the location of the highest combined stress ratio in the upper portion of the tower. Well, there's no measurements in here other than if it collapses, it's going to go down into a 78 by 78 compound, which is the dimensions of the base of that fence that you referred to. So I want to know what the measurement is on the section if it folds over, how long it is, or how tall is it? Is it 100 feet of the 5-foot tower? Is it 25 feet or such? And the The engineer in this evidence doesn't state any dimensions of that other than if it collapses, it's just going to collapse into the 78 by 78 area.
Yeah, question.
That's why I asked.
Sure, absolutely. Thank you for your question with respect to the structural elements of the site as well as the details with respect to height and other elements of that site. I would just state for the record that we'd be happy to advise Mr. Glancy's office of that once the application were deemed complete.
Okay.
What's the distance to the nearest resident? Excuse me.
Go ahead. You're there first.
While he's looking that up, just as a point, it's been 16 minutes on this section, so however you want to handle that.
We're kind of in the question and answer phase. I
That's
know.
fine.
It's about 390 feet from the nearest property line, which would be to the north.
Okay. Are there any other
Sure.
questions at this time?
Yeah, I have one.
Yes.
Do you guys have inspectors once these towers are built?
Yes, we do. So there's an inspection process during and to complete the construction, and then there's also a maintenance process, quarterly maintenance approximately that come to the site for maintenance of the compound and making sure that the facility is running from a safety perspective and operational perspective as well.
Are these persons mentioned in the folder that they will be part of that?
I don't know if the exact engaged individuals are referenced in the application materials.
We have any further questions at this time?
I got a couple more.
Go ahead.
Some could probably wait for deliberations, but the gentleman can come back up to answer further questions if I understand the way we do this. One, I'm going to refer to your 3-ring binder and this document right here that shows kind of a cover of the engineering study and the picture of the site, the aerial site location.
Yes, sir.
In the bottom section, it says compliance code down at the very bottom in the center of it.
Yes.
And it says all work, and I won't go through each one of them, but there are probably about 10 or 11 bullet points that cite different building codes, electrical codes, concrete institute, construction, TIA 607, blah, blah, blah. Nowhere on that, and I believe this is trying to infer that the codes and the standards that the engineering study was performed within were done by these codes within the context of those codes.
I think that's a fair
Fair
summary.
assessment?
Yes.
Why is the Grant County area-wide zoning ordinance standards not included in the codes that are referenced?
That would ultimately be supplemented by the application, the permit application, which was included in your original packet as opposed to tonight due to its size, which was supplementing those drawings that you just referenced.
So I can have assurance that when the design of this tower and the dimensions were considered, all of those factors, the
Yes.
engineer was abiding by our zoning ordinance as well as all of these other codes?
Yes, and ultimately your planning department office is a checks and balances for that as we submit drawings and a permit application and supplemental materials for the planning office to ultimately issue a building permit or a tower permit.
I have a couple other questions, but I'll wait for deliberations.
Okay.
Maybe
Anyone
some
else?
other board members might cover the same issue.
Okay, you may be seated. Thank you. Is there anyone here in opposition to this petition? Please come forward. Seeing none, we'll move on to we'll move on to Mr. Glancy for you to present support of your administrative decision.
We'll just try to keep track of time here. To answer your question, Mr. Duke, the building codes, I believe you're looking at, that first page is the 2014 Indiana Building Code. That'd be what is in our ordinance. We follow that code for the engineering standards. We don't have a lot of engineering standards in our Grant County Code. It basically refers back to those codes, if that answers your question.
Actually, my question was, and I was thinking in terms of the other standards that we have in the area-wide zoning ordinance that talk to the setback requirements and the dimension requirements and the adjacent property requirements and so forth. When we talk, it talks in terms of the height allowed, the fall, the distance it has to be from residential properties and so forth.
Okay. I was thinking engineering wise.
Well, to me, that all relates in an engineering equation as well.
Okay.
So, thank you.
You're welcome. So this matter is an appeal of administrative determination. The question before you tonight is not whether wireless service is needed and not whether the applicant is a qualified provider. The question is whether the applicant, as submitted, complies with the Grant County area-wide zoning ordinance on this particular parcel. So the ordinance recognizes the importance of wireless service. And under 153.581, there are 5 points. But I'm only speak to 4 of them, A, B, C, and E. The county, to summarize A, B, C, and E, the county is to facilitate service, encourage placement in non-residential areas, and to ensure towers are properly sited and do not result in inefficient or incompatible places. So that's a summary of A, B, C, and E. Under 153.604 in our ordinance, towers are permitted in general business district, and they are not permitted in residential zoning. So the requirement's pretty straightforward. The tower and its associated facilities must be located entirely within the general business portion of the parcel. So this is where we might want to take a few notes here. I'm going to throw a lot of numbers. The subject parcel is approximately 176 feet by 185 feet. It is split evenly between general business and residential. So that leaves approximately 88 feet of width in the general business portion. So under code 153.606 in our ordinance, a tower of approximately 195 feet, I'm reducing it by the antenna, requires 205 feet from the property line and 390 feet from a residential property line. When those requirements are applied to this parcel, the available area is significantly less than what's required. If you'd like me to do this again, I can.
Second one. From the property line and then from the,
So for a tower, the setbacks are based on tower height. for a tower of 195 feet. The ordinance requires 205 feet from the property lines and 390 feet from a residential property line. This is basically surrounded by residential. And so when those requirements are applied to this parcel, the available area is significantly less than what's required. As a result, the tower and associated facilities cannot be located within the general business portion of the parcel in compliance with our ordinance. This is not a matter of interpretation or judgment. This is a matter of physical space and ordinance requirements. So the applicant has presented information regarding services needed and broader considerations. Those are not the issue in this appeal. The determination was limited to whether this application on this parcel meets the ordinance. It simply does not. So in addition to the record, let's let the record show that there is agricultural zoning located approximately 1,144 feet from this site. There's also a large tract of I-1, Industrial 1 property located approximately 282 feet away. No documentation has been provided demonstrating that those or other non-residential properties are available or have refused to accommodate this proposed facility. So the role of the Area Planning Commission is to apply the ordinance as written. The ordinance allows wireless facilities. It requires that they be properly located and properly sited. This parcel does not meet those requirements. So for that reason, the application was not accepted for processing, and I'll stop here for any questions.
I have a question. It says in here, in your documentation, the required 390-foot setback from residential property lines cannot be achieved given the adjacent R1 zoning and split parcel configuration. And the proposed tower cannot be located entirely within the general business portion of the parcel while remaining in compliance with the ordinance. So if the 390-foot setback cannot be achieved, how far is the tower from the nearest residential property itself? What's the closest property, residential, to this tower?
Even within that parcel. I mean, the parcel's only 88 feet wide.
No, I mean, how far is the nearest house from the tower?
Well, I do not know the answer to that question precisely. All I know is the ordinance states residential property line. So we're going by the property line and not by the residential
Okay, I'll
home.
revise my question to the property line.
Okay,
How far is that from this tower?
I do not think I have precise numbers on that.
Do you have an estimate? This drawing is a picture, but it has no scale of distance. So I'm kind of curious as to, is it about 200 feet? Is it about 100 feet? What, is it about 400 feet? What is your best?
I don't have those. I don't have those numbers.
Mr. Hartman, if I might,
Yes,
if I draw your attention to the
another
white
picture.
rock materials in, I don't know how many pages back, but it's the aerial view with the bullseye circles on it. It shows that my estimation, it's not an exact number, but the nearest house appears to be within a 200-foot radius. In the 200-foot radius of the circles that are drawn on here that range from 100 feet, 200, 300, 400, 500 feet. And it's like 5 or 6 pages back of the. What's this one here?
I think I just found it. Thank you. Okay. Are there further questions? I was wondering about the abandoned building on the site. Is it going to be removed?
I do not know. Do you want to wait until?
Okay. And how close are you to that building then? Pretty close, right?
It was one of those things that after I found that the parcel is not close to being large enough for the tower based on our setbacks and requirements in the ordinance, didn't matter where the building was.
Okay.
Okay.
Are there any other questions?
Our ordinance doesn't have a section for cell towers and the distance between the cell tower and the residential buildings. That's why I didn't investigate it.
It's the property line.
It's the property line
That's fine.
for residential properties.
Okay, so. I think you may be seated. I don't think we have any questions right now. Yes, sir, you have up to 10 minutes if you need them to for your rebuttal.
Thank you, Mr. Harmon. With respect to the more detailed questions regarding the site, Mr. Hartman, that you just offered, if you did have our construction drawings, which are tab 2 of the binder or included in your previous packet, you can move to really any of the pages after the initial one and see an 80 by 80 compound site. And you'll see that the boundary of that 80 by 80 compound site on the north and the west is ultimately just off of the property line to the west and to the northeast.
I saw that.
And as far as distance to the northeast corner of the existing structure, I don't have that specific distance, but I'll estimate 15 to 20 feet or so from the fence. Recall that the tower sits within the middle of the 80 by 80 compound. I did misspeak in my initial presentation with respect to distance to the nearest residence. I'm just finding out what that number is, and before I leave the podium, I'll offer that. That would be the residence just to the northeast would be the closest residence, and I'll offer that number. There was a comment made by Mr. Clancy that no evidence of refusal by others in the general proximity. We have we can submit written evidence as needed with respect to that, but we have discussed that point, including one site owned in part by our current landowner, that site has ultimately been deemed unavailable for this tower site. It would have essentially the same issues that I'm standing before you discussing today. There are also 3 agricultural sites to the south and southwest, and those landowners have refused as well. And then there's one additional site to the north that has refused a lease or long-term easement arrangement as well. So we have 5 or 6 within the gap coverage area, because that area is very small. The Verizon analysis has to create a radius. That radius is small, then we have to find a location within that radius to sign an easement or sign a lease. We then have to sign that lease, and then we have to submit the permit application. So this is the only parcel that we have been able to identify within that search radius that will fill the coverage gap that we could be submitting an application for. The comment about that the ordinance, must be followed. Certainly agree with that in principle, but I also encourage the board to not necessarily view the Grant County zoning ordinance within a vacuum, particularly with respect to telecommunications service, the development of cell towers. It needs to be viewed also through the lens of state law and federal law. My initial presentation commented about how the state law and the federal law preempt, trump, otherwise supersede certain provisions of the local law. We certainly argue that the application should be accepted, because then that would allow the county, if it so chooses, to exercise its rights under that law. For example, as we've offered in our letters or other correspondence, if the county has an issue with that certified letter, that fall zone letter, or any other analysis, the county can engage its own service provider, its own engineer to rebut that. But our evidence as submitted in our application shifts that burden over to the county. So I would urge the Board of Zoning Appeals to accept the application as supplemented and as submitted. As a follow-up to my earlier comment, as far as the proximity to the closest residence, while this is not an exact number, I expect the worst case scenario to be about 85 feet, the compound site to the nearest residence. Again, compound site, fall zone letter, the tower would fall within that compound site. Compound and all of the improvements, access and utilities, all within the zoned general business area. Any other comments with respect to details of the application or questions with respect to the application can be answered if the application is deemed complete. So I again urge you respectfully to deem it complete tonight. Thank you.
I will ask one question. If you could summarize, and this goes to the question I was going to ask, you've touched on it. I was going to ask for a description of how many other locations had been pursued and before ending up on this particular location.
It was an effort that included this location, given that some of those parcels were partially owned by our landowner, but 5 to 6 most recently.
Were those all ag?
No, some were ag, some were industrial, and some were general business.
Could you talk to how many of each?
I don't have those numbers. I can certainly field those numbers as needed. I believe at least 3 ag, at least 1 residential, and at least 1 industrial. And then, of course, this site would be the general business, part residential.
You said you could present evidence that documents those approaches to those other.
I do. I certainly have a map on my phone that's clunky for tonight's presentation. I'm going to point you in the direction of. Let's see if there's a map I can show you. maps in your materials would do justice to answering the question, sir, so I'll leave it at that.
Fair enough.
There are limited opportunities within the search radius.
Okay, you may be seated. Thank you.
Thank you.
This time it's open for board deliberations and discussion. The public hearing is now closed.
I make a motion that we support the executive director's findings.
I'll second.
I've got a question before.
Okay, let's
If we can,
hold
I ask
up on the motion for just a minute. Go ahead with your question.
Okay, I know what our ordinances are, but if there's federal or state ordinances dealing with telecommunications, is that something as a board we need to be concerned about as well?
Well, we have our area-wide zoning ordinance in front of us. It has not been changed. I don't know that it's been challenged to be changed. At this point, it's our law book here in Grant County. I think you probably can make your decision based on that until we are determined otherwise.
I'll ask a question of our legal counsel.
Okay, feel free.
Is our ordinance dealing with cell towers and wireless communication towers, 153 and all the dot sections? It is consistent with existing state law.
The state statute will trump our ordinance. So in other words, if our ordinance is in conflicts with the state statute will rule out our local ordinance.
Okay.
We cannot pass ordinances against state statutes.
So we did pass it at some time.
Correct.
And it was consistent with state statute.
Well, I can't answer at that time. I think the issue you're getting at, Mr. Duke, if I'm following you correctly, is the collapse zone and what the state statute says versus what our local ordinance says. As this gentleman has pointed out, our ordinance is okay, except once they have an engineering report which determines that the structure will collapse within itself, basically, then the burden shifts to us, according to the state statute, to have an engineer that says otherwise, which then could bring our ordinance back into play. So it's not that our ordinance is wrong. It's just that in this particular case, the state statute would trump our ordinance because no evidence was presented by a professional engineer on our behalf, which showed otherwise, if that makes sense.
Yes, that makes perfect sense, and that basically is the passage within the state code, IC codification that was referenced as to the point, or the main point of this appeal. That's why I'm questioning that.
It's a little bit hard for us to get in the minds of the people that drafted our ordinance and everything they considered when they made us setback. It may not be just based on fall zone. There may be other reasons they considered, like how close should it really be to a residence? Is there any interference with radio waves, television, anything else? How they made that ordinance, I don't think any of us can say. But it may not have been just based on safety of the tower falling over or collapsing. And they may have made a decision based on, well, even if it does fall, it's well within the setback that they've created. So those are questions that I don't think any of us can really answer as to why the area-wide zoning ordinance has the setback it has. But it is our law at this time.
And in relationship to the engineering study, fairness, you can back into any number you want to come up with where you think it might fall. And counter to that, that doesn't mean that a different engineering study might find differently. That perhaps it might fall farther than within that 80 by 80 parcel. So I mean, I read what you're referencing to, Dave, about the fact that it's that the engineering study per fall zone can be challenged based with the different engineering study. It would suggest that there was an issue with the initial engineering study.
I would just encourage you to reread section 17 under Indiana Code 8, which he's provided, 8-1-32.3-17, or paragraph B, especially the however paragraph there at the end. That's pretty definitive. But that only applies to the fall zone requirement, not the other.
That's exactly correct.
Right. That's only just one specific point of Mr. Glancing's findings. I just want to make sure you're clear on that one point. There were other issues also.
Yeah.
And Mr. Hartman has also brought up some points about our other parts of our ordinance.
Fall zone restriction B, though, of the one you just cited, Indiana Code, says requirements for all fall zones cannot exceed the collapse area certified by an engineer unless the authority proves the certification is faulty.
And I understand what that says, Mr. Ellis.
But then the next sentence says the permit authority's evidence must include a study performed and certified by a professional engineer.
Agreed, understood.
I guess I'll just state for we're on the record. From a common sense perspective, I will admit I'm not a professional engineer, but I can add numbers and I can read. At least the university I graduated from tells me so. Common sense in applying common sense to reading the engineer letter that gives the representation that this will collapse into the area, this general business. It says it's a 78 by 78 area that it will collapse into. Well, in the center of the tower, it's 39 feet that way, 39 feet that way, 35 feet or 39 feet either side. I will question openly, going back to my question about length of sections and structural portions of the tower, how long it is. Common sense tells me if that thing comes down, I don't think 39 feet either side of the center point of the tower is going to contain it. Now, that's a layman against a professional engineer's opinion. I realize that. I also will make the comment that the engineering opinion was based on wind velocity and magnitude of a windstorm event. It didn't talk to earthquakes. It didn't talk to a crop duster flying through the area in those agricultural fields across the street and miscalculating or, becoming disoriented and crashing into the thing. None of those kind of circumstances are talked to in that. It's just wind force, solely wind force.
Well, I
So
think that's why Mr. Hartman's comment becomes relevant of what else was in consideration when that ordinance was put into place. That might even be what he was getting at, frankly.
Like, was there a consideration of an accident or sabotage? Take out one legs of a three-legged tower, common sense would tell you it's going to fall, not collapse. So anyway, again, it's hard to get in the minds of
Sanders got a question.
what brought our setback ordinance. And is it unreasonable? Or and we're deciding if this is the location that's acceptable.
Respectfully, board, you're not deciding the merits of a cell
Excuse me,
tower.
the public hearing is closed.
I'm the petitioner.
I know that. But the public hearing is closed and you had your time.
I certainly
We've
still
moved
have
on.
rebuttal time, but I would encourage the board to consider what matter is before you.
You don't have any more time, sir. Please sit down.
Thank you, sir.
Final deliberations.
So I have a question also. I'm fairly new at this. So hypothetically, if the board deemed the application was complete and the petitioner was allowed to proceed with the plans to come before the zoning board, would they have to address these issues at that time? Would we address those issues with them before we would pass the request? Because I'm hearing that we're not addressing whether or not we would accept this, just the fact of whether we would allow it to come that far.
Right.
My second question would be if we did not, and the state law would preempt county law, would that then open up legal issues for the county?
Yes, it could. And we would probably go to the next step, which would be judicial review by the Circuit Court or Superior Court of Grant County, where they would dive into these issues too. And so I guess that's all I'm going to say about that, really. Are there any more questions or deliberations from the board? Then the decision is whether or not we uphold the decision by the office, or do we overturn that decision or modify it?
Another question?
Yes, sure.
Sorry.
No?
So, Mr. Glancy denied
The application.
the application
Right.
because it didn't meet the
The
criteria
ordinance. Yes,
that we require.
right.
Is the purpose of this board to address those variances that don't meet that, or? Because it seems like every issue that we deal with, there's some special something that's not quite within the guidelines, and we have to determine if it's appropriate to proceed and allow someone to build a pole barn or whatever. So I I guess I'm having a little trouble understanding how not being within compliance of the county's zoning boards prevents it from being a complete application. That's all I'm
Right,
questioning here.
yes. And Mr. Glancy and the office made their decision based on the area-wide zoning ordinance. And they have come to appeal to us to overturn that. And so that's our decision, whether or not we uphold his decision or whether we overturn it or modify it. So I'm not sure I'm helping you any, but that is our situation. And any further deliberations? Then I'll entertain a motion.
I make a motion that we support our executive director's findings and our county law in regards to this
I'll second.
appeal.
We have a motion by Mr. Ellis to uphold the decision. We have a second by Mrs. Jones. Mr. Glancy, would you give us a roll call vote, please?
Michael Duke,
Being cognizant of the Indiana code citation and recognizing that that is there to be contended with, I will vote yes to support Mr. Glancy's decision.
Andy Ellis,
Yes.
Lois Jones,
Yes.
Chad Kirkpatrick,
Did you say no?
No.
Okay.
Sandra Rowan,
I say no.
Mr. Hartman,
I say yes.
motion passes.
Okay, we upheld the decision. You have your answer at this point. Thank you, sir, for your presentation. Okay. At this time, what time do you have, sir?
8:45,
7:45.
7:35, sorry.
Okay, we still have a few things on the list. List of permits. Could you include that in next month's packet? Summary of permits for 2025, the same. 1812 special exception report. Could you include that in the packet?
Just pass it out now real quick and
You could pass it out now real quick and we'll review it for the next meeting. Based on the fact that we have greatly exceeded our allotted time, I'll call for a motion to adjourn.
So moved.
Second.
We have a motion to adjourn by Michael, a second by Sandra. Thank you. At this time, we're adjourned. Thank you, everyone.
Question.
I'll answer it.
Okay, so when I'm filling this out and marking yes, so the approval will not.
You can turn off the recording.
Oh, thank you.
If I say
Nice having a little
yes,
help.
that means it will not be considered.
It would not. There. So if you're, in order to support a